EEOC mediation is a process that happens, or I should say an opportunity that is offered to some charging parties or persons that are bringing charges against employers and employers early on in the administrative process that the EEOC is responsible for taking care of. Normally how it happens is immediately after a charge is filed with the EEOC, if it's not dismissed because there's a lack of merit, the charge is routed up to the Alternative Dispute Resolution Department, again, that houses the mediation section of the EEOC, and they determine whether the case is worthy for mediation. If it fits a certain criteria, it would warrant mediation. If it's selected by the EEOC for mediation, then the parties are contacted, the employer and the employee, and they're invited to mediation. Mediation is a voluntary process, and both sides and the EEOC must agree to the mediation for the mediation to go forward. If one side decides not to participate or declines EEOC mediation, then the case would enter back into the investigative track. Before accepting an offer to mediate, which if you haven't been represented by an attorney at this point in your EEOC charge, I would highly recommend that you contact an experienced attorney that is familiar with EEOC law, because this is a great opportunity for you as the employee to cut down some of the time that could be associated with the investigation, to get similar remedies up front with less cost to you, and oftentimes it's similar or better than what could be achieved at the end of an EEOC investigation or after the matter has been filed in court. So it's an opportunity that you really should look at based on the strength of the charge and the facts. And again, it's a case-by-case scenario, so there's not one blanket answer, but I always refer employees to mediation when the case and the facts warrant such. The beauty of having an experienced employment lawyer that is experienced with EEOC law is you don't go to those mediations unrepresented. One of our attorneys, not a paralegal, not legal staff, an attorney will actually sit there with you, make sure that your claims are forwarded, because oftentimes the employers will show up with high-powered lawyers, and they're representing their interest in their job, and their interest is to walk away from the table with as little damage to them as possible. But with an experienced lawyer, you can make sure that that EEOC mediation process is fruitful for you and successful, to make sure that your claims have been addressed and that some of the remedies that you were seeking has been made whole. So if you're at that point where you've been invited to EEOC mediation, or you feel that it may be pending soon, I would highly recommend you contact a lawyer experienced in that area so that they can walk you through that process. It can be very fruitful for you and speed up the process of your charge of discrimination.